Can everybody still hear me?
Yes, we can.
Okay.
I'll be watching since we do
Okay.
have 41 panelists. I'll be watching that mute. Sorry about that.
That's okay. All right. So I do not work for State Fund or for any other insurer. And I know a lot of people sometimes are confused by Montana State Fund or Department of Labor. We are not the same. Department of Labor is different than Montana State Fund. I am not a lawyer or a claims adjuster, so I cannot give you legal advice. And every claim is going to be fact specific. So we can talk in generalizations if you have a question about a claim, but just know that just because some of the facts might be the same as a coworker or somebody that you know doesn't mean you're going to get the same outcome. There we go. And this is what we're going to cover today in our presentation. I kind of wanted to say, please give me feedback. Please interrupt if you have questions or you just don't understand. Just say, hey, wait a minute, stop, Cindy, I don't understand. There's no dumb questions. There's no wrong answers. So please interrupt or raise your hand or type in the chat box. And please give feedback because it helps me to determine what you guys really want to know about work comp. Like I said, a lot of it doesn't change, but if there's other aspects that you want to touch on in the future, give me feedback on that. So Montana's work comp system is a little over 100 years old. Every state and jurisdiction is different. It's administered at the state level. So that means every state is going to have different benefits, different rules, different regulations that regulate the work comp in their state. So it's definitely not a one-size-fits-all federal program that's mandated to the states. Each work comp program is specific to that state. And work comp is mandatory in this state if you have employees. There is some exceptions to that, which we'll talk about on the next slide, but employees include undocumented workers, minors, part-time or full-time employees. So the point of work comp is not to make the injured worker whole, but it's meant to provide benefits to the employee at a reasonable cost to the employer. So work comp is the only remedy available to injured workers. They can't sign their rights away, and that's what's part of is known as the exclusive remedy principle. And the goal of that is just to provide benefits to workers who are injured on the job or benefits to those workers who are killed on the job. And so the exclusive remedy principle, I like to say, means there's no backroom deals. An employer can't say, hey, work for me and I'll pay you $20 an hour instead of $10 if you promise never to file a work comp claim against me. Or an employer cannot say, this is my personal favorite, hey, I know you got hurt, but don't file a work comp claim. I'll just pay for it out of the company business. Well, that's great until they don't pay for that. So don't ever let your employer say that to you. I've heard that a few times, which makes me cringe and horror because it's so illegal. Also, employees don't have to prove that their employer was negligent. The employee can't sue even if the employer's foolish or careless acts directly contributed to their injury, and they also can't sue a fellow coworker for negligence. The benefits available to them under statute are what is available to them, regardless of if the employer's at fault. Now, there's a lot of exceptions in work comp. Sometimes people want a black and white answer and you can't always give them a black and white answer. There's a couple exceptions to this exclusivity principle. Fraudulent concealment or assault and battery removes the employer from that exclusivity principle and they open themselves up for lawsuit. So if you are an employer and you have a disagreement with your employee, do not physically attack them as a means to settle your dispute, because that's going to open you up to not only a work comp claim, but also possible lawsuit as well. The work comp system is a no-fault system, and that eliminates the need to determine who is at fault. Excuse me. It ensures that workers who are injured receive benefits, but it also limits the employer's liability and helps protect them from costly and unpredictable lawsuits. So we want it to be fair for employees as well as employers. Here is a partial list of exempt employments under statute for the work comp. And I've referenced statutes throughout the slides that reference the topic that we're talking about in case people want to go back later and look up that statute and really get into what it really means. So this is just a partial list. Like I said, it does not mean that they are exempt from other payroll taxes such as unemployment. It just means they're exempt from work comp under statute. Now they can choose to purchase a policy for themselves, but they don't have to. They're not required to, like other employments in the state. The most common are going to be household or domestic employment or dependent members and spouses of an employer. So in the state, there are 3 options for coverage. Plan ones are going to be the self-insurers, and they have to obtain authorization from Department of Labor and maintain that security deposit. So self-insurers are going to be big companies like Targets and Costco's and Albertsons and Safeways. Those type of companies are going to self-insure. Private carriers are Plan 2, and they kind of are going to choose who they want to insure based on your modification factor, which as an employer, you should understand your EMOD and how that ties into your premiums for work comp. I think there's close to about 200 private carriers in the state, but not all of them are actively writing policy. And then Plan 3 is going to be state fund. So they're a quasi-government agency providing coverage in Montana, and they're also the market of last resort for employers who can obtain coverage through a private carrier. So costs are going to vary between carriers and also based on your EMOD, your experience modification, based on how many injuries you've had in your workplace. But benefits are going to be identical because they're outlined under statute. So if you're thinking about shopping around maybe for a new work comp carrier, keep that in mind about pricing and make sure you understand what your experience modification is and how that's going to determine pricing from those carriers. So do we have any questions so far? Okay, the next thing I want to talk about is the Uninsured Employers Fund. And this is our way, this is the department's way to ensure that all Montana workers have access to work comp benefits. So employers, you should realize that every person on your job site should be covered by a work comp policy, or they should be an independent contractor. We are averaging about 52 claims a year for Uninsured Employers Fund, which is about 1 a week, which I think is not good at all. So this was created, like I said, to provide those benefits to employees that are injured on the job. They're entitled to the same benefits as an employee who was injured for an employer who actually had work comp coverage. The only difference is going to be that medical benefits are capped at $100,000 for the Uninsured Employers Fund. For regular work comp, there's no cap on those medical benefits. Let's see. Next. So an uninsured employer is going to be subject to a $200 fine or 200% of what the premium would have been for that uninsured period, whichever is greater. And you can assume that 200% is going to be a lot greater than a $200 fine. So we can also do a 3-year look back on those uninsured employers to see what the premium would have been for that 3-year period. And then we're going to assess penalties and late fees, interest. The department can also order an uninsured employer to cease and desist until they are bound by a compensation plan. And every employer who doesn't comply, every day that you're out of compliance is a separate violation. It's a misdemeanor, it's a separate violation. Now, I'm not sure if we have any general contractors out there in the audience today, but if you're a general contractor, you need to make sure that all your subs have work comp coverage, because if we find a sub that's uninsured, we can order that sub to cease and desist all operations until they are bound by a compensation plan. And if we come back 3 days later and find out that sub hasn't complied, then we can shut down the whole project. So if you're a general contractor, please make sure that your subs have work comp coverage. And I always like to give examples of stuff because it kind of helps people understand. So this is an example that was given to me by the folks who manage the Uninsured Employers Fund. And they had a claim about 1.5 years ago for an individual who was working as a roofer. Roofers seem to have an abnormally high level of injury. So this worker fell off the roof. It was during the wintertime in between a building and a big snow pile, and he landed on his back. And so he had some tingling in his lower extremities, and his boss happened to be uninsured, decided there's nothing wrong with you, just walk it off, you'll be fine, rub some dirt into it. Well, the worker didn't really think that he was fine. So they ended up calling an ambulance, took him up to the hospital. They took him to surgery, and they were not able to repair the damage. So as a result, the person is an incomplete paraplegic, which means that this person will never walk again. He'll never work again. And the sad thing is that was his first day on the job. So maybe some employers think, well, I'm just going to roll the dice and maybe I get caught, maybe I don't. I would not recommend that, because that person could also turn around and sue you now as an uninsured employer, plus the state's going to go after you as well. So monetarily, it doesn't make a lot of sense to be an uninsured employer. At the last clinic I did a couple months ago, I had somebody ask me, if you're an independent contractor and you get hurt, can you file a claim under uninsured employers? And the answer is no, because as
Oh,
an
there we go. I can hear you now. Nope, now she's gone again.
Tanner, can we mute everybody, please? So anyways, as I was saying, so as an independent contractor, you have the option to purchase work comp. If you choose not to and get hurt, you can't come to the Uninsured Employers Fund because you're not an employee. So I hope that makes sense to anybody out there who may be an independent contractor or who knows an independent contractor. So any questions on that? All right.
We're not seeing any at this time, and sorry, we're moving. I'll be moving all the panelists that we have over to attendees.
Okay.
Just because there's some that are joining that automatically come in as panelists and they're not
Yeah.
muted. So I apologize on
Okay.
that. No current
Okay.
questions though, Sydney.
Okay, perfect. So we're going to move on now and talk about Montana's public policy. And so the legislature decides what rules and regulations govern the work comp system and how they are applied. And then Montana's public policy is going to lay out those rules and regulations. And the first one is we want to provide medical and wage loss benefits to injured workers. So the wage loss benefit should bear a reasonable relationship to the actual wages lost. And the statute defines that as 66 2/3% of your average weekly wage. We want to return the worker to work as soon as possible, utilizing that stay at work, because we want to provide benefits to mitigate any negative financial impact it's going to have on that employee. And it's proven that a worker's removal from the workforce because of a work-related injury has a negative impact on that worker, which is kind of a given. Reasonable and constant rates for employers. We want to minimize reliance on lawyers and the courts, and that's also part of that exclusive remedy principle. And so the system is self-executing, and it's designed to function and provide what it's supposed to without an injured worker needing to hire an attorney. Sometimes it's necessary. I get it. I've seen enough work comp cases come through where lawyers are involved. But just keep in mind, if you choose to hire an attorney because of a workplace injury, you got to weigh the risks and benefits. And I'm not knocking attorneys, but it can be a long, difficult, and very stressful process that can take months or even years. And so if you choose to go down that road, just make sure you understand everything that's involved with that. It's not in favor of either party, and benefits are not available for stress claims. They are only available for physically compensable claims. Now, if during your injury, you develop PTSD or you develop, I'm sorry, Tanner, am I still talking? Can you still hear me?
Yeah, I could hear you just fine.
Okay, I don't seem to have. Okay, so if benefits are not available for stress claims, if you have a physically compensable injury and you develop PTSD or depression, then those conditions can be treated. However, if you cannot file a claim in this state for PTSD or depression as a work-related injury. Unfortunately, in the state, we just don't have that right now. The legislature decided those are hard to objectively verify, and they have the potential to put an enormous strain on the work comp system. And the whole point of the system is to help employees, but also to keep costs down for employers as well. And then my last bullet point there about occupational diseases, and those are recognized with some different reporting requirements. Those occur over more than a single day or shift. And then requirements reflect consideration of when the worker knew or should have known that their condition was related to an occupational disease. Whoops. So next thing I want to talk about is extraterritorial agreements. As I mentioned, each state has their own work comp laws. And so if you partner with a business out of state, you want to make sure that you understand and that they're in compliance with work comp laws. So extraterritorial agreements were designed to help Montana businesses that contract with out-of-state businesses to perform work in Montana. And that kind of allows employers to bring or send employees to another state without having to purchase work comp in that state. And this is really more on the eastern part of the state where the oil boom was really going hot and heavy there for a while. We have reciprocity with 7 states around us. And a temporary, you can bring or send on a temporary basis, which in this state is 6 months. So this applies to all industries except for construction. Montana does not recognize other states' work comp policies in construction industry. So any construction contractor that comes into Montana has to have Montana work comp coverage. Effective last February of 2019, Wyoming construction contractors are eligible to come into the state on a temporary basis, which is less than 6 months. All right, course and scope. There's a couple slides that we're going to discuss on course and scope, and this is very important for employers to really understand how this works to help determine if injuries are work-related. So course and scope was developed to determine if the injury is work-related. So when you're planning activities or job duties as an employer, you kind of want to keep this in mind. And I know right now with a lot of people working from home, planning activities like Christmas parties or this past summer picnics kind of went by the wayside, but hopefully we'll get back to normal. And this is going to apply to all holiday parties or picnics or anything that you do outside of work. So when you're planning this stuff, you want to think about, did the injury occur on the job? And was the employee actually doing his job, or was he horsing around? Has the employee substantially deviated from his course and scope? You also want to think about that as well. So course and scope says the injury must arise out of employment. It has to occur on the employer's premise or job site during regular work hours. So for some construction companies, they might have remote locations. So that's the same. It doesn't have to happen in your corporate office. It can be your premise or a job site if it's a remote job site. That is covered as well. So the Montana Supreme Court has a 4-factor analysis that they developed to help determine if activities that happened were in course and scope. So the first one they said is whether the activity was undertaken at the employer's request. So as the employer, did you tell Joe to go pick up that 50-pound hay bale and he threw his back out? if that's the case, if you told him to go do that and he hurt himself, that's more than likely going to be a work comp injury. The second one is whether the employer directly or indirectly compelled the employee's attendance. So this is where it comes in for holiday parties or picnics. If you have something that's after hours, make sure that your employees know it's not mandatory that they show up, because if you make it mandatory and they show up and they're injured, more than likely it's going to be a work comp injury. I like to use this example. It's been a couple years now, but one of my coworkers, at her previous employer, they had a Christmas party at the bowling alley, and it was mandatory that everybody attend. And what do you know? Somebody got hurt. So because even though they were bowling and doing a group team building, however you want to say it, since it was a mandatory that you be there, it was a work comp injury. So number 3 is whether the employer controlled or participated in the activity. And the last one is kind of controversial. I seem to get a lot of comments on this, whether the employer and the employee mutually benefited from the activity. So this is, I'll take a case here where a couple years ago, I had an employer say to me, well, my employee went outside to shovel the sidewalk because it had snowed, and he slipped and hurt himself. And I didn't ask him to do that, and I don't think that should be a work comp injury. Well, just because you didn't ask him to do that, that's not necessarily how it's going to be looked at, because there's some mutual benefit there, because that employee was helping his employer by clearing that sidewalk off of snow. And there's some mutual benefit for the employee because he's participating in the job and doing the best that he can to his abilities. He doesn't have to, he wasn't told to, he's just being a proactive employee. We have a few people in my building who take it upon themselves to go out and shovel our sidewalks every time it snows. Now, they're not told to do that. They just do it because it helps them as well as the rest of the employees in the building. However, if they were to be injured, more than likely that would be a work comp injury. So any questions on this course and scope so far?
Let's take a look. I am not seeing the at this time.
Okay, so the next thing we're going to talk about is there was some legislative changes that were made to course and scope back in 2011. The legislature developed some additional guidelines for clarification. So all 3 of these have to be met for this to not be considered in course and scope. So it says the injury does not arise out of employment when the employee is on a paid or unpaid break. And so this kind of gets confusing sometimes, because whether it's a paid or unpaid, the status of the break, whether it's paid or unpaid, is irrelevant. If it's a break, is not on the work site of the employer and is not performing any specific task for the employer. So this does not apply though if the employee is injured on paid time or whose attendance is required or requested by the employer. So don't ask your folks to do stuff that they're not qualified to do, because if they're injured doing that, it's probably going to be a work comp claim. And so on the next slide, we're going to talk more about a break, because some people think of a break as just a 15-minute break that you take twice a day, or a 30-minute lunch break, but that's not necessarily the definition according to the legislature for breaks during work. So I also want to point out too that this third bullet point here, not performing any specific tasks. So if you know your employees takes a 15-minute walk break every afternoon, and you ask them, hey, stop by the post office on your walk break and drop off this mail. And on the way back, or on the way to the post office, the employee gets injured. So do you think that's going to be a work comp claim? Probably more than likely, because she's performing tasks for her employer during the break. So don't, like I said, don't ask them to do anything that they're not prepared or not trained to do. I know dropping off mail is pretty easy to do, but I'm just giving that as an example. So any questions on that so far? All right. Going to keep moving along here. Now I have some court cases and some explanations for the most commonly asked questions about course and scope. And the first one is called comings and goings. And so what that says is employee is not covered when they are going to and from work. So if they suffer an injury while they're traveling, they are not covered unless, here we go with some exceptions, the employer furnishes the transportation, or the employee receives reimbursement for travel costs, or the travel is required as part of their job. So when an employee travels to and from work, employers have no control over how that employee gets to work. So if they get in a wreck on their way to work, that's not going to be a work comp injury unless they are in transportation furnished by the employer, or they're traveling, maybe they're traveling out of town to go for work. That's different. If they're in their own vehicle and they're traveling to work and they get in a wreck on the way to work, that's not going to be work comp until they are on the site of the employer. So the premise rule now is an exception to the comings and goings rule. And in most cases, the parking lot is going to be considered part of the premise. So the premise rule says once the employee has arrived at the employer's premise within a reasonable work time, they're no longer coming and going, and they're in course and scope of employment. And I've referenced court cases where this has been decided and where it affects the law. Once a court case is decided, it can affect statute based on the outcome of the case. So a reasonable time, now that's kind of vague. If your employee gets there 2 hours before their shift starts and they get hurt, that's not really reasonable. If they get there 5 minutes before their shift starts and they walk across the parking lot and fall and bonk their head, that's pretty reasonable, 5 minutes before their shift. Now, like I said at the beginning, each claim is going to have to be investigated, but in most cases, the parking lot is part of the premise of the employer. So breaks, and I talked about this on the last slide. So breaks, an injury does not arise out of course and scope when the employee is on a break. And so a break is any break where they are not performing any specific task for the employer, and there's no restrictions on where they can go and what they can do. So the legislature does not limit the statute to short breaks. It applies to any break regardless of the duration, where they're not performing tasks for their employer and there's no restrictions on where they can go. So there was a case that came up about this with regards to a travel or a flight attendant on an airline. So she was saying, I was on a break, and the work comp court said, no, you were not, because there were no restrictions on what you could do or where you can go. So just keep in mind that a break is not necessarily a 15-minute break or a 30-minute lunch break. It's any break where the employee is not performing any duties and they can come and go as they please. So travel is another one I get a lot of questions on. So it is well established that traveling employees are not covered 24 hours a day, regardless of the conduct or activity. So to remain in course and scope, the employee must be traveling to remain in that course and scope. And a traveling employee is not within course and scope merely by staying in a city away from home. So if I travel to Missoula to give a presentation and it's 5 o'clock at night and I go to dinner and have a glass of wine and fall and trip in the parking lot and hurt myself, I'm not in course and scope at that point just because I'm staying out of town. My day has ended at 5 o'clock. I'm on a break, if you want to look at it that way. There's no restrictions on where I can go. I can go to dinner. I can sit in my hotel room. So if I get hurt, more than likely that's not going to be a work comp injury. So I know this is pretty important stuff. It's kind of dry, but if there's any questions on course and scope, please let me know.
Yeah, we
go
have
ahead.
a couple questions.
Okay.
And some more might come in. We have an older one that it came back about 10 minutes ago, but it was saying we also consider if they are on the clock. And again, they said, sorry, this is delayed. They used the
Is that
question
for
and
course and
answer.
scope?
I don't know. I'm guessing it was prior if, if somebody was leaving to somewhere or got injured, if they were on the clock.
Yeah. Okay.
Um,
Yep.
If that was somebody that wrote, you're more than welcome to expand on it so we could follow up with you. Again, it came in from Casey Keller West and we got like 60 of them with just the name Casey Keller West. So I apologize if I can't address it specifically to you. Another
Okay.
question came in, Cindy, is how do you avoid cases of their word versus yours? For example, an employee gets in an accident on the way to work, but suddenly claims you asked him to go pick up supplies wherever from the job site.
So that's a good question. Now, whenever there's a claim, I mean, if the employee says, well, you told me to pick up this material and I got in a wreck, and so it's in course and scope. So first of all, they have to report, and we're going to talk about this more on reporting requirements. They have to report the injury, and it's going to be investigated. The work comp carrier is going to investigate the claim. They're going to ask all the parties involved, and they can make a determination based on that as well. So another thing I want to stress to employers is if you're going to have your employees, I mean, it's your word against theirs, the best thing that you want to do in this case is just have them fill out the first report of injury and let the insurer investigate the claim. That's what you're paying them for. If there's any claims adjusters on the call, let me know your point of view from this. But we've always been told to just file the claim. It doesn't cost employers anything if they file a claim and there's no costs associated with that claim. You're not going to be dinged by your insurer. So your word against theirs. This is going to protect employers from bogus claims as well. Just file that first report of injury, let your insurer investigate, and they're going to determine if it was in course and scope. So I
Right.
hope that answered the question.
Great, thanks, Andy. We'll see if there's a follow-up on it. I had two more questions if you got a
Okay,
couple
yep,
seconds.
absolutely.
Under coming and going, any idea when the expectations was implemented? I know many people who pay for commuting, yet employee is not on the clock, but this is saying they would still be covered.
So yeah, this is kind of hard for some employers. Just because you're not clocked in doesn't mean you're not on their premise. And so you can reference the statute that I have here. You can dig into that more. But they're saying once, oh, I'm sorry, we're talking about the premise rule. There was this case here, Massey versus Selensky, that was decided by the Montana Supreme Court. And I believe this is the one where the employee had arrived on the employer's premise in the parking lot, was pulling his bike out of the truck to show his friend and injured himself, and it turned out to be a work comp claim. So like I said, everyone is going to be different. All the facts are different, but based on that case, they're saying once they get to work within a reasonable time, they're in course and scope, whether they've clocked in or not. Now, I mean, I'm sure that's up for debate. I'm sure some claims adjusters will say, no, you weren't clocked in. There's the debate on that, but the premise rule is pretty, I mean, it's been established by court case, so it's pretty uniform. Like I said, if there's any adjusters out there, let me know your take on this as well.
Right, I appreciate that, Sydney. The last one, it might not be in your wheelhouse, but it's just, has there been any cases of workers' comp being used for COVID?
Actually, yeah, we had this question a couple months ago. We have had a couple COVID claims that have been accepted, and those are going to be frontline workers like healthcare providers and first responders. I have not heard of any cases in the workplace where you caught COVID. I think it might be a little more difficult to prove that as an occupational disease that you contracted COVID through your workplace. That's a little bit harder to prove than healthcare workers and first responders. So I have not heard of any cases where somebody in an office environment has a claim that's been accepted. I know some have been filed. I'm not necessarily sure that any have been accepted at this point.
Great. Thanks, Cindy.
Mhm.
That's the questions that we have as of right now. If you wanted to get back,
Okay.
hopefully you
All
know
right.
where you're at. Thank you.
Yep. So we're going to move into the reporting requirements. And what this says is, I always want to stress this, that employees always have the right to report an injury. And it's kind of interesting that less than 20% of them do within the first 24 hours. So, and insurers always want to know about workplace injuries because they're looking at trends where there's a lot of close calls or near misses, something that can be maybe addressed to mitigate a future injury. So an injured employee must notify their employer within 30 days. And that can be oral or written to a supervisor or a manager, but not another coworker unless that coworker's in a project manager supervisory role. So you need to document the time and place and the nature of the injury, and actual knowledge of the accident by the employer is equivalent to notice. So here again, the courts are really clear on that. If you do not report the accident within 30 days, you cannot file a work comp claim. There's just no exceptions to that. So I always tell an employee, if you're injured, you can submit it orally, but it's easier if you put it in writing, because a lot of people can't, if they're like me, I can't remember what I did last week. I'm not going to remember something you told me 2 weeks ago. So put it in writing. That's just easier. It just covers you and the employer as well. So there's no he said, she said issues that come about from that. So, and it can be as simple as, if you do it orally, say, hey, I tripped on the parking lot and bonked my head, but I think I'm okay. So, if that's the case, the employer has 6 days to notify their insurer, and most insurers are going to want to know within 24 to 48 hours. So make sure that you just follow the guidelines that your insurer tells you with regards to reporting claims. So an injured worker has 12 months from the date of injury to submit that first report of injury. So if you do not report that injury within the first 30 days, you cannot file for benefits. That's clear, and there's just the courts are not going to give you any leeway on that. Let's see, next. So claims for occupational diseases have to be filed 1 year from the date the worker knew or should have known that their condition was from an occupational disease. And so that could be if you think you have carpal tunnel and you go to the doctor and your healthcare provider says, yeah, that looks like you have carpal tunnel, then that kind of starts the 1 year clock, because now you know that that's your condition, and more than likely it's resulted from being a typist for 20 years or being a mechanic on your knees for 30 years and your knees are shot. That kind of starts that 1 year process that you have to file that claim. And insurers have 30 days to accept or deny the claim. Now they can also put it under what's called a reservation of rights. They can make payments within 30 days without admission of liability, or they can make payments on medical claims without accepting liability. So what this does is if they haven't had enough time to research the claim within that 30 days, then they can put it under a reservation of rights, and they're still investigating the claim. And most times the holdup is they haven't received medical from the medical provider or the healthcare provider. So that's usually the holdup to help them determine whether this injury was in course and scope. So reporting is pretty important when you have an injury. Make sure that, I always try and tell people to put it in writing if you can. I mean, you can mention it in passing, but if you have to go to the doctor 3 weeks after you mentioned it in passing and your manager doesn't remember that you mentioned it to them, that could be an issue. So it's just best to put it in writing. Okay, so when are you actually eligible for benefits? If you have an injury, which is harm or death caused by an accident. So the employee must meet the burden of proof. They have to prove that it's more probable than not that their accident caused the injury. So why this is important is we talked about this a couple slides ago. This helps protect the employer from the bogus claim. So we talked about getting in a wreck on the way to a job site, or maybe you have an employee who came in on a Monday and he says, oh, I was lifting up my keyboard and I threw my shoulder out or something like that. Well, did he really do that from the keyboard, or did he play too much golf over the weekend and his shoulders inflamed, or is it just part of the natural aging process where we get older and things just don't work as well? So in that case, send him, fill out the first report of injury, send this person to the healthcare provider, and they're going to say, yeah, that looks pretty consistent with picking up a keyboard, or he's going to say, there's no way this injury happened from picking up a keyboard. And that's going to protect employers from those bogus work comp claims. That's going to cost them a lot of money in the long run. So I threw in a couple slides here for people to figure out how to file a work comp claim if you have an employer who is not very, what's the word, who is not very helpful in assisting you to do this. And this should never be the case where your employer won't let you file a work comp claim. No, that's just not acceptable. Also, I've had a claim, or I had a phone call a couple years ago from an injured worker who said her employer wouldn't let her fill out the first report of injury, and so she went to the doctor. The healthcare provider can also help you fill out that claim as well. And so the healthcare provider helped her fill out that form, but then her manager showed up at her house that night and started screaming at her on the porch. So don't be one of those kind of employers. That's just not acceptable behavior from anybody. So you can go to our website, and here's the website. Here's the link. If you go to this page, you want to click on data management forms. And it's going to take you to this page where you're going to click on the first report of injury form. And then it has instructions above if you're unsure on what parts to fill out. And whoops. This is kind of what we want you to fill out. What's most important for the injured worker to fill out at the time, if they're able to, depending on how severe the injury is. This is kind of the fields. And the insurer is going to come back after that first report of injury is received by them, and they're going to go over the information with you and fill in any blanks that they might have, and just to make sure they understand the story from the injured worker's perspective. I got these slides out of order. I wanted to show you this as well. As we talked about at the beginning of the presentation, workers' comp is mandatory in this state for everybody. And these posters should be displayed in break rooms and in the back, in the shop area, anywhere where employees gather. There should be this work comp poster along with minimum wage law and those kind of things, saying that you have work comp coverage through your employer. And I circle this here. If your employer is giving you grief, which again, please don't be one of those employers, about filing that first report of injury, you can submit it directly to the insurer. And in this case, for Department of Labor, we're insured through State Fund. Or you can contact us right below here, Employment Relations, and say, hey, I'm having trouble trying to fill out a first report of injury. My employer is not cooperating with me. So that's also an option for workers who are injured and who are having some issues with their employers not cooperating with them filling out the paperwork. So any questions before we move into the benefits on what you receive from an injury?
Looking good. I don't see any questions as of right now.
Perfect. Okay, so once you have a work comp injury, the first thing, you're going to be eligible for medical benefits, and those are going to be reasonable and necessary to treat your injury. And we want to ensure the most appropriate medical care is provided. And we do that by utilizing our utilization and treatment guidelines. And this is effective for all claims on or after July 1st, 2011. And these are evidence-based. And if So insurers are not responsible for treatment or services outside those guidelines. Now, I had a situation come up a couple weeks ago where an injured worker called and said, hey, my healthcare provider wants to do a treatment that's outside of the utilization treatment guidelines, and the insurer says they're not going to pay for it. Well, the insurer doesn't have to pay for it if it's outside of those guidelines. However, the healthcare provider can work with the insurer and obtain prior authorization for that procedure if that is going to be something that's going to work better than a more costly and longer treatment for that injury, if that makes sense. Oh, travel expenses. So if you have to travel, if you live in a small town, maybe you live in Townsend and you have to travel to Helena for treatment, you will be reimbursed for your travel expenses for lodging, meals, reasonable travel, at the same rate that us state workers are reimbursed when we travel as well. And I had a really interesting question last week from an injured worker who said, hey, my car broke down. I have no way to get to my healthcare provider. And so I took Uber or Lyft to get to my medical appointment. Is that going to be reimbursable? And I said, wow, that's a great question. I said, that's something you're going to have to talk to your insurer about. And I touched base with one of our insurers, and she said, now this is just one of the claims adjusters. She said that's absolutely expenses that she would approve, because that is a travel expense. She has no other way to get to her medical appointment. So I thought that was interesting in this day and age of Uber and Lyft now. People are using it to get to their healthcare visits as well. All right, injured workers also have the right to choose their initial treating physician, but that physician has to be licensed in the state of Montana, and that treating physician is going to be responsible for that coordination of care. And treating physicians can refer the employee to another healthcare provider for treatment if that initial treating physician isn't trained or qualified to treat the injury. Maybe you went to a general practitioner at first and you actually need to go to an orthopedic. They can refer you to that. And after accepting liability, the insurer can change your designated treating physician if they decide, again, that your initial treating physician isn't qualified or capable of treating, they're not a specialist, and that's what you need. So they can redirect treatment to another physician in that case, once they accept liability for the claim. So injured workers are also eligible for wage loss benefits, and that's going to be 2/3 of your average weekly wage, not to exceed the state's average weekly wage of $849. I know some people are going to make more than that, and some people are going to make less, but there again, it's meant to be a reasonable relationship to the actual wages. So there is a 32-hour or 4-day waiting period before you receive those wage loss benefits. 32 hours or 4 days, whichever comes first. And the reason that it's written that way is because some employees might work 12-hour shifts. So they're probably going to reach the 32-hour mark before they reach their 4 days. If the injured worker is out of work for 21 days or longer, they're going to be retroactively paid that 4-day waiting period. But keep in mind that employees, you can't double dip. So if you took sick time during that 4-day waiting period and you're out for longer than 21 days, you're going to either have to decline the retroactive payment or you're going to have to repay your employer for that sick time because you can't double dip. Now, this is only for sick time. If you took vacation or PTO time and during that 4-day waiting period, that's okay. Then you can accept the retroactive payment. Here we go. Death benefits are also available for family members of workers that are injured on the job, and they're going to receive 2/3 of the salary of the injured deceased worker at the time of death. It's going to be paid to spouses for up to 10 years or until that spouse remarries. and children and beneficiaries for up to, I think, 18 years or 21 years if they attend university. There's also a one-time $3,000 payment to the parents of a deceased worker if they have no beneficiaries at the time of their death, and there is a one-time burial expense of up to $4,000 as well. Voc Rehab Benefits are going to be available to workers who are disabled, which is defined as a permanent impairment that precludes them from returning to their time of injury and they have actual wage loss, or 15% or greater impairment with no wage loss. And so they can work with the Voc Rehab provider through the work comp insurer, and they can help develop a plan to retrain them to do a job that maybe they can do. If maybe they're a bricklayer and they're right-handed and their right hand was smashed and they can't be a bricklayer anymore, they can possibly be retrained to do something else using their left hand, something that they can do and earn a living and still stay in the workforce. And benefits will be paid for this for up to 104 weeks with a written plan with that Voc Rehab provider. Now, this is a new law that was put into effect last year for the presumptive firefighter coverage. This applies to firefighters covered under a current work comp policy. This went into effect last July for firefighters with at least 1 year experience. And so they're presumed to have a claim for an occupational disease if it was caused by a firefighting activities. And so the disease must manifest within 10 years. And in this case, here's another exception. Usually for regular work comp coverage, there's no cap on medical. In this case, they capped each claim for these presumptive occupational diseases at $5 million per claim. So this is only available to volunteer firefighters if the employer has elected coverage for them. So there's no coverage yet for volunteers unless who you're volunteering for has elected coverage for you as a volunteer firefighter. And you can go to the statute, you can look it up online, and it has a whole list of the diseases that are going to be covered under this and how long you have to have had this disease before it's going to be covered, because each disease is going to have slightly different requirements for this to kick in. Oh my gosh, I am just getting spammed here. Okay, let's go to the next slide. So 5-year closure. So this was put into effect. This was part of the legislative package that was implemented for work comp reforms back in 2011. This rule does not apply to prosthetics or permanently totally disabled claims. And so this was put into place, and it's kind of been a huge cost saver in the work comp system. It's resulted in about an 8% reduction in the system costs because after the claim closes, insurers don't have to collect a reserve like they did before this rule went into effect. And what it says is medical benefits automatically terminate 60 months from the date of injury. This is going to be for claims on or after July 1st of 2012. And so if your claim closes, you can petition the department. You can petition me to have it reopened. And what you're going to do is just go online and work with your claims adjuster, or you can call me directly and we can get you set up with the petition form. And this is going to be for benefits to help that worker stay at work or return to work if they haven't fully healed after 5 years, depending on the injury that they sustain. So the benefits will remain open. Requests must be made within 5 years of the termination. And you have to bring evidence to support that reopening. You have to provide evidence to support why you want to reopen your claim. And it's going to be reopened if it is reopened. If the medical director or the panel review decides to reopen it, it'll be reopened for 2 years at a time and then reviewed every 2 years after that to see if benefits need to continue after that 2-year mark. Benefit resolution. So this is the mediation process. And the intent of mediation is to meet that minimal reliance on lawyers in the courts. That's part of our public policy, because we want to resolve these disputes quickly and not have to move through all those lower courts like they had to do before. So mediation is mandatory, it's informal, and it's non-binding. It's also confidential. And right now we have an 80% resolution rate. So before you can move forward with a claim to the work comp court, you have to go through mediation. And if it's not resolved, if either side figures, you know, this is non-binding, I don't agree with this, so I'm walking away and I'm going to go to work comp court and take my chances there, you can do that since it's non-binding. So if it's unresolved in mediation, it will go to the work comp court. And the reason this was set up is because we wanted to eliminate those delays and expenses of moving through those lower courts to get a resolution in this case, because we want to get those benefits decided quickly for those injured workers. So any questions on work comp before we move into the stay at work portion?
No questions.
All right. So I've got a couple slides to talk about stay at work. Got a few minutes left here. So we'll talk about stay at work. Let's see. So keep in mind that work comp is not designed to be a substitute for return to work. It just provides temporary care and support. You want to eventually get back to work as an injured worker and get back to your job and get back to your full-time earnings. An important factor of return to work is that occupational bond that exists between workers and employers, and it should be mutually beneficial. If you're working, you should be receiving some benefit to that work. And when injuries happen, sometimes that bond becomes unglued, and that sets up the opportunity to have a lot of misunderstandings and unclear expectations, and it becomes confusing, and there can be some issues involved with that. So despite our best efforts, employees get injured. So what are you going to do? So the first thing is early intervention is the key to managing those workplace injuries, and you want to have a plan. Everybody has a plan. They have a plan for what they're going to do this weekend. People have financial plans. People have 5-year plans. Corporations have strategic plans. You should have a plan at work on how you're going to deal with workplace injuries, and be proactive in addressing those injuries and illnesses, and work that plan that you put in place. What is return to work? So at its most basic, it's just getting that injured worker back to work as soon as possible to the same position with the same employer, or a modified position with that same employer. And a modification could be, you know, here's some examples: working shorter hours, taking more breaks, or performing transitional duties. Successful return to work means you get to keep that valuable employee, and it limits the financial impact on your work comp premium. We talked about earlier the experience modification. This is definitely getting them back to work quickly is going to mitigate your increases in your work comp premium. So benefits for the program. So employers with fewer injuries pay less. That's kind of a given. And less time off work equals less impact on your premiums. So claims close faster with light duty, and it minimizes the impact on your experience modification. So if you have a medical claim only, if you have a claim with an injured worker and you get that worker back to work within that 4-day waiting period, so all you have is medical that on that claim, at the end of the claim, your insurer is going to discount that claim by up to 70%, because that's their incentive to avoid wage loss. But if there's any wage loss on that claim, you're going to get 100% of the costs are going to count towards your premium. So that's a huge incentive to get your injured worker back as soon as you can after the injury. Returning to work speeds that injured worker's recovery. It keeps that employee connected to the workplace, and it promotes faster recovery and prevents that downward spiral into disability that happens sometimes with injuries. Reduces the financial impact on the worker. The longer the worker is off of work, the greater the impact on their long-term earnings. And some employees might think, great, I'm getting paid to sit at home. I'm getting 2/3 of my salary. If you walked up to an employee in a normal office environment and said, hey, you want to take a 33% pay cut, they would say you're out of your mind. But people think I'm sitting at home on work comp, I'm getting paid. They don't realize they're not getting as much. And it's a possible reduction in their income by up to 30 to 40%. They're just not going to get as much on work comp as they would at their job. Reduces physical and emotional health effects. The longer they're out of work, the harder it is for them to return. And it may reduce the risk of re-injury because it helps reduce that depression, anxiety, substance abuse, stuff like that. So some employers are probably thinking, well, why is this important and why do I care? Why does this matter? Because what if people had a positive experience? Would the outcomes be different? And what if it were you? How would you want to be treated if you were injured? Think about that. If you're a supervisor or an employer, if you were injured, how would you want to be treated? Because happy people, we want in our system, in the work comp system, we're aiming for happy people, cost reductions, and back to work equals back to life. So return to work is good for your employees. And a return to work, an effective strategy, encourages communications between the employer and the injured worker. Allows a skilled and experienced employee to keep working for you. Effective communication is an important component in that injured worker's recovery. Studies show the odds of a worker ever returning to work drop 50% by just the third month, and 50% of them never come back after 6 months. So keep in communication with your employee, and don't be one of those employers who I've talked to that say, my worker is out on work comp and I don't know when they're ever coming back. And I asked them, well, have you talked to them? And they said, well, no. Well, if you're an employee and your employer doesn't care if you come back to work, why should you care? So make sure you maintain that good communication there. Keeps loss of productivity to a minimum. It reduces the cost of training new employees, and it creates that opportunity to complete work that you just never have the time to do, jobs that just never seem to get done. Those are good opportunities for stay at work, return to work. If you have some stuff, maybe you're switching from paper files to electronic files and you need someone to scan all of those into your system, that's a great use of return to work to bring employees back. How your employees benefit is it keeps that employee active and it speeds their medical recovery. Studies show when an injured worker remains connected to the workplace, injury rates greatly improve. Shifts the focus from disability to ability. It keeps that injured worker from dwelling on their injury. And work provides, excuse me, one of the most therapeutic, you might think otherwise, but one of the most therapeutic ways for pain relief because it's a distraction. The more you focus on your job, the less you're going to focus on your discomfort. Allows the employee to maintain contact with coworkers. This is really important because for a lot of people, your workplace isn't just a job. It's a place where you go to socialize, to see your friends, to talk about plans for the weekend or what you did over the weekend. There's that huge social component there. So bringing them back to work maintains that contact with their coworkers. And it shows your employee that you value their contributions to your company. So how do you create a successful return to work strategy? You need to believe in the program for your company and for your employees. You need to, it should be part of every new employee orientation so that all employees know what's going to happen if there's an injury. And train your managers on your supervisors and your supervisors on how you are going to manage those employees. Develop that written plan. And then if you can, designate a return to work lead who's going to be ideally responsible for helping that injured worker attend their initial healthcare provider visits and any support they need through that process. So quickly, I'll go through this. This is our pre-injury model that we use if we provide the stay at work benefits. Most insurers are using a similar model. So before the injury, you want to establish a strong safety program. Like I said, address any processes where you notice there's a lot of close calls or near misses. Be proactive, identify light duty positions that you could use in return to work opportunities. Report all your injuries to your return to work lead. And and understand that there's going to be some increased awareness of these psychosocial barriers because they have the loss of contact with their coworkers. Substance abuse is huge. Chronic and permanent disability, if they're cut off from their workplace and they spiral down into that disability state, just be aware that there can be some increases in these as well. In the post-injury model, begin your return to work efforts the first day or within 72 hours. Stay in contact with that injured employee. I just cannot stress that enough. Make sure you check in weekly or bi-weekly or set something up where you're checking in with that employee. Utilize the medical status form to determine if you have any duties that you can have this injured worker perform, and respect their confidentiality. After the employee returns back to work, this is pretty important. Regularly check with them to see how they're progressing. Make certain that restrictions or any work tasks are being met. And this is really important. Discourage any hazing or negativity surrounding that injured worker, because if you've done as an employer all this work to bring that injured worker back and they're going to be teased or harassed by their coworkers because, well, I have to do extra work because you're injured and so I have more work to do. That injured worker is not going to come back to work and you've just wasted all that time and energy for nothing. So make sure that doesn't happen in the workplace. And then make sure you notify your claims manager if you're not able to accommodate any ongoing restrictions so that they understand what's going on as well. And then the last slide I have is just an example of sample light duty job description on how you would go about setting that up. And make sure that expectations are clear for the employee as well as the employer. And that's all I have today. If I have any other questions from you out in the audience.
Great. We'll give it a second to see if anybody has any questions. Cindy, I just wanted to thank you so much for you being able to get on.
You're welcome.
In the ABC
You're welcome.
clinic. You do a phenomenal job and we always love having you.
Thanks.
And this year was a little different. We didn't have any, for all you folks out there, all the attendees, we didn't have any in-person ABC clinics this year because of COVID. And this is our second, basically our third ABC clinic.
I think so.
On the virtual side, and a lot of people really like them. There will be a questionnaire, there will be some information sent out for you guys to fill out, so please put that to good use because we do look at it and what works best for the state of Montana. So thank you so much. I don't see anything coming in. Cindy, I think you're off the hook easy. We did have some questions earlier.
Okay.
But if they do come in, we could for sure email them to you, and then we could
definitely
get them sent out that way. So.
And if you guys think of anything after the fact, please email me, reach out to me. I can definitely help you. And I want to say a shout out to Carl. I have not seen you in forever, Mr. Carl Mon, and I hope you're doing well. All right,
Doing
everybody.
Good seeing you.
You too. All right, everybody. Thank you so much for attending today.
Appreciate it. Thanks, Cindy, so much. All right, everybody. If you wanted to take a quick 2-minute, 3-minute break, we're going to get the next presenter up. Go ahead and fill your cup of joe up or use the restroom. We're going to get started with Carl Mon here in a second. Carl, if you wanted to maybe see if we could get the PowerPoint up and going, if you wanted to share your screen, see how we got. Great. All right. Looks good. We'll start here and let's just give them a minute or two.
Yep.
Carl, if that works.
You just give me the word and we'll get it going.
So a lot of you have came in under Casey Keller West's name and we don't see your name. I apologize for that. Some of you came into the panelist section where the presenters are held and they have rights to their mute button and to be able to see chats and to do a lot more activities than the attendees. Since we had a handful of people speaking, they'd come in and their microphones would be on. We switched everybody to the attendees field. The attendees field, you could still operate the chat and you could listen in. You're just muted. So that is a safety precaution that we do have because there has been a handful of Zoom bombs out there. And that's something that we don't want throughout the state to close this presentation down. So that's kind of why you've gotten moved if you had a question on that. I've mentioned at the earlier part of this, if you do need credits, continuing ed credits, CPA, SHRM, HRCI, or even legal credits, please make sure you put your name and what credits you do need in the chat box. You will need to attend all 4 days to be able to receive those credits. We'll be tracking that, and then next week, the following week, we'll get all that emailed or mailed out to you for the certificate, and then you could use that. Again, if you have any questions, feel free to put them into the chat, regardless of any of the topics that we have today or throughout the week, and we could get them prior, or we could address them when that presenter is up and available. All right. Well, we had a couple minutes. Hopefully everybody is getting back. Next, we have the Montana ESGR. That's the Employer Support of the Guard and Reserve. We have Carl Mon. He's a technical support specialist with the LexisNexis Risk Solutions out of Bozeman. He's a U.S. Army retired, 29 years, and his last position was held as a battalion. I can't wait. I'm not saying that right.
The battalion operation.
Yeah, I don't know why I can't say that. Operation NCO with the Montana Recruiting and Retentions. I'm sorry for butchering that.
That's
He has a
okay.
B in organizational management, and he's been volunteer with the ESGR for a while. And we can't thank you enough, especially even after Veterans Day, for your time as well. So thank you very much, Carl, and thank you for joining us today. And I'll turn it over to you.
Awesome. Thanks, Tanner. And thanks, everyone. And good afternoon. I just probably saw many of you last year at the clinic in Bozeman. And I'll just preface the presentation that we do have a full-time member that supports the ESGR here in Montana. Her name is Parker Taylor, and I will be providing the contact information for her. So any questions you may have, she's the absolute subject matter expert on that. I can take some general questions that you may have, but she's certainly going to be the one that's going to get you the information you need for any particular scenarios that you may have. So as Tanner was saying, the ESGR is a Department of Defense program for information, education, and for mediation for Guard and Reserve members, better known as Reserve Component members. And these are all folks that are employees of yours in a civilian capacity, as well as employers concerned for the Ucera rights and responsibilities that both that they have to you, as well as the employer has to the service member. We do cover all 7 service components. That is the Army National Guard, the Army Reserve, the Marine Corps Reserve, the Navy Reserve, the Air National Guard, Air Force Reserve, and the Coast Guard Reserve. So the ESGR is here for you as a current or future employer of any Montana Guard and or Reserve members. Again, my name is Carl, and my regular duties, since I've retired from the military, I work as a technology support specialist. Yeah, I can't say it either now. For LexisNexis Risk, it's a global company that primarily, in my capacity, deals with anti-money laundering and support to any organizations that utilize transfer of funds through banking. So I'm here today to help you understand more about the Employer Support of the Guard and Reserve, the ESGR, and the Uniformed Service Employment and Reemployment Rights Act, the Ucera, and to help you understand the resource of the ESGR, what it can do for you when you're hiring a reserve component member. And I think that you may have received the Ucera booklet. If you haven't, again, you can get that. The resource is available online, so you can get that handbook from there as well. And I'll provide you that information here in just a little bit. So the ESGR, it's a DoD program for information, education, mediation for reserve component members or service members and their employers concerning their Ucera rights and responsibilities. The ESGR serves all 7 reserve components, which we discussed. The employer support of the Guard and Reserve is a DoD program that it works with the Department of Defense. It was established in 1972. It is the lead DoD organization for this mission under the DoD Directive 1250.1. The reserve component members do comprise roughly 50% of our total force. What that means for you as a taxpayer is that half of our military force is part-time, and so that what that means to us as taxpayers is it's a significant savings of not having to have that, twice the amount as a standing military. The ESGR consists of a network of thousands of volunteers throughout the United States, Guam, Puerto Rico, and the Virgin Islands, and the District of Columbia. So they're folks like myself who basically do this as a volunteer effort. So how do we promote positive relationships? The SGR does this primarily through advocating for mutually beneficial initiatives. That is the mutual benefit of having a reserve component member as one of your employees, recognizing outstanding employer support, and that is providing that appreciation for what you do for those members, increasing awareness of applicable laws and policies, resolving potential conflicts between employers and their service members. This is very important. And acting as employer's principal advocate within the Department of Defense. Some of our outreach at different events, such as speaking like to you all today through the ABC clinics, fairs. We have different employer events, educational military flights for current and future bosses of our service members in cities across Montana. I'll talk a little bit more about that as we go as well. And some of you I know have probably participated in some of that, and be sure to let some of your colleagues know that when these opportunities arise to take advantage of them. It's all free of charge, and it's a phenomenal opportunity. So what we want to get into then is education and advocacy. We basically want to cover through the advocacy that the ESGR does the rights and responsibilities for the employers under the Ucera law. We also want to encourage the development of good HR policies that may go above and beyond what the law supports for the military. And just an example of that is we have some companies who provide additional benefits for employees who may be deployed overseas or for state active duty, like this summer with the forest fires we had in Montana, to help with that situation. Also educating employers with ESGR events. So when we do have these events such as boss lifts, we provide some additional information to help employers understand the benefits, again, of hiring members of the reserve component, as well as some of their obligations to you as their employee. Recognizing employers who meet or exceed the law with the My Boss Patriot Awards. And these are awards in some cases where the service member can nominate their bosses for these awards. And in a case like this year, we even had an individual spouse. There's the spouse award was done for an employer. It was for the spouse's employer to thank them for their support of her through her husband's deployment. So what does Ucera stand for? It stands for U.S. employers are really, really awesome. And this is very true. It's the employers of our service members who allow them to be able to continue their service as a reserve component member in a part-time capacity. So it's really, really important that they understand that they have the backing of their employee, or I'm sorry, of their employer while they're gone. Because as you can well imagine, not only do you have the concern of getting ready to be gone for an extended period of time, we just had units that returned from a year-long deployment overseas. So you have that concern of being away from your family and worrying about your family during their absence. And then if you had that additional stress of concern about their employer maybe not standing behind them in some fashion, that could be, add some additional stress to them. So what is Ucera then? This is the actual law. It's the federal statute that protects the service members and veterans' civilian employment rights. And among other things, under certain conditions, Ucera requires employers to put individuals back to work in their civilian jobs after their military service. Ucera also protects service members from discrimination in the workplace based on their military service or affiliation. And so to understand how the basic law works, service members must be treated exactly like similar employees who are not in the military and have never left for service time. In the law, Congress's intent was to ensure service members were not penalized in their civilian employment because of their service. And again, these folks are giving of themselves in support of the defense of their military, of their country, as well as their state, if they're members of the Army National Guard and the Air National Guard. And we don't want them to feel like it's it's a negative aspect for their employer for them to be a member of these very worthy services. So the primary purpose for the Ucera is to encourage non-career service in the uniformed services by eliminating or minimizing the disadvantages to civilian careers and employment which can result from such service. Also to minimize the disruption to the lives of persons performing service in uniformed services, as well as their employers, their fellow employees, and their communities by providing for the prompt reemployment of such persons upon their completion of such service, and to prohibit discrimination against persons because of their service in uniformed services. So then we want to get into who this applies to. So the Ucera law covers returning from a drill weekend. It covers a return from training. It covers return from active duty or deployment. So any of you that do have the Ucera flip books does provide some specific details on that, as well as the website that I'll provide to you at the end of the presentation. The Ucera law has implications for the service member when they apply for a job, after they leave a job, and as long as they're employed. All employers are covered, even if you only employ one employee and they are in the Guard or the Reserve, both full-time and part-time employees are covered. If you are in the National Guard and Reserve and are a partner, owner, or an independent contractor, Ucera does not apply. So those bosses, I know we have some who are a member of the Guard and Reserve, that this law does not cover them. So serving in the Guard means they have two bosses. They have the governor and the president. So for presidential call-up, they will fall under Title 10. This federal authority over the service members falls under the Title 10 of the United States Code. These laws do apply to active duty, reservists, and the Guard members who are ordered to federal level active duty for federal level missions. Funding comes from the federal government, like the president is the boss. So in this case, generally, as an example, any deployments overseas to the Middle East or to Africa or to Europe, Eastern Europe, these are generally going to be Title 10 type activations. Title 32, which is federal authority over the National Guard members, falls under Title 32 of the United States Code. And what this means is it's considered federal active duty for specific state missions and full-time Guard positions. This type of state level activation is guided by the state laws and policies, but is funded by the federal government after approval from the president. This typically happens with large-scale state-related missions, such as major natural disasters, for example. The governor is the boss, even though the state mission is sanctioned and funded by the federal government. So again, the example in this particular case is the forest fire season that we had this past year, where they called up members of the Guard, both Air and Army. Those individuals, it's under a state call-up, and they're covered under this Title 32. And there is, let's see here, there is the state active duty for Montana military service employment rights, which this, you all are probably familiar from this from the state side. The employment rights are covered under Part 10 of the Montana Code annotated. These rights are similar as they're similar rights as the Ucera while supporting the governor's call up to support state emergencies, fires, floods, blizzards. Okay, so just to recap that, Title 32 is a governor's order and Title 10 is under presidential order. Okay. So how the ESGR advocates for the employer. So now we've talked about the Ucera, which is the law, and then the ESGR, which is the organization who provides advocacy for both the employer and the soldiers. If there's an undue hardship on the employer, the ESGR does have opportunity to speak to the service members or to the unit commander to help with the situation. If you have a service member who volunteers all the time for duty, if having the service member out for 5 months will be a hardship, please do give the ESGR a call. We do know that smaller organizations or smaller companies may experience greater hardships in these particular cases, and this is where the ESGR is well suited to help out with that. In Miles City, for example, we had 4 police officers. They were set to be deployed with the National Guard. The mayor of Miles City, was very, very concerned that the deployment of so many from a small police force was going to create a very undue hardship for the town. So the ESGR was able to help out with the problem, and ultimately through the work with the ESGR and the Adjutant General for the state of Montana, they were able to reduce the impact of those individuals. So what that basically meant is they had a lesser number of those police officers that ended up deploying. We had another incident where ProLube, they had a service member who was on like a week-to-week order. ProLube, the manager there just didn't know from week to week if they were going to be able to let their manager know that they could work. So they worked through the ESGR to see what could be done about that. The ESGR actually reached out to the unit commander to let them know, kind of what kind of a problem this is causing them, and that the employer needed help to put them on a monthly, so there was some stability and the ability to know for both the soldier and for the employer, what the expectation was as far as their leave from their job, from their civilian job. So this ended up being a compromise that helped out to at least help the employer be able to anticipate what or when their employee was going to be back. So the keys to success, if you understand the Ucera and you know who to call for more information, it makes your job from the HR side and as an employer much easier. We know that BNSF the military scheduler for the entire United States had actually traveled up to Great Falls for a C-130 flight at the request of her 2 Montana Air National Guard members. She was thrilled to be able to attend her at her own expense to support her Guard members. So these are things that are, once you truly do understand what the requirements are and what the law says and how you can interact and work back and forth with your employee who's a service member, it makes life a lot easier for everybody. And it reduces that stress, like I said at the beginning. Okay, so leave of absence, we're going to jump into that. Furlough or leave of absence for employees that are away for military service deemed to be on leave. They're entitled to non-seniority benefits like others on leaves of other kinds. So we'll get into the meat and potatoes here. So to be eligible for rights under Ucera, you must be employed by an employer. You must have left your employer because of military service, and you must meet all of the following requirements. So prior to notice to the employer, you must provide you have to provide notice to your employer that you will be performing military service. A notice may be verbal or in writing, but written notice is highly encouraged. And this is something that we always tell our service members. You must communicate with your employer. If it's talking about your weekend drill schedule, these weekend drill schedules are planned a year in advance. So at the beginning of a fiscal year, that employee should be able to give the drill schedule for the remainder of the year from starting October through September of the next year. There may be exceptions, of course, if there is that active duty call up or there's a state active duty call up for emergencies where that would be outside of the bounds of that schedule. The service member also needs to serve under honorable conditions. Your period of military service performed must be honorable or under honorable conditions. Dishonorable or bad conduct or other than honorable discharges, dismissal and drop from the roles forfeit Ucera protections. So if your employee deployed and through their service, they were released from the military for something that was dishonorable, bad conduct, or something along that line, they are not protected. So that individual would not be able to return to you and say, look, I'm covered by Ucera protection and I need my job back. So that's something to keep in mind there. That would be a very rare incidence, but where there's something rare, that means it's happened, I guess. That's what I always say. Return to work in a timely manner. This is a responsibility of the employee. After performing your military service, you must formally apply to return to work in accordance with these Ucera time guidelines. You don't want to mess with any of these timelines. If you miss them, your employer can consider you AWOL. I bet you didn't think that you could consider your employee AWOL, but you can. So maybe, just the employee needs to follow standard company policies. Otherwise, they can be terminated if they're absent without notice. And so you can see the Ucera timelines. For instance, from 1 to 30 days, they need to report back to work on the next scheduled work day. So if they return back on Sunday, they should be back to work on Monday unless they make some type of an arrangement with their employer saying, I got back late last night or something, and you can make some allowances for that. And then going on up from 31 to 180 days, they have 14 days to essentially get readjusted back to home schedule and things of that nature. And then 181 days, it gives a 90-day period. Now, in most cases, I can tell you that the employees are going to want to come back to work prior to that time, but this just gives the maximum extent there. Okay. All right, so the question is, does Ucera protect a service member for both involuntary and voluntary mobilization? You may have some employees who need to volunteer for military training that's for their advancement into higher levels of responsibility. That would basically be considered voluntary, but it is something that they need in order to continue their service with the military. So long story short, there's no difference between voluntary and involuntary service. And this also applies to the weekend drills. Next question is an employer required to give service members time off to go to drill? And the answer is yes. They do need to be given reasonable time to go to drill, both to and from. And just as an example, my own son, he lives in Great Falls, and he has to drive down to Dillon for his weekend drills. And it takes him a good, about 5 hours travel both ways. And so that time frame, and if he needs to have, if the drill is scheduled to begin at 6 p.m. on Friday, then the employer should be giving them that adequate time to be able to depart and travel to their location where they're drilling. Okay, now there's some discrimination policies here. Here's a question, can I not hire persons in the service who is considering joining? It sounds like a problem to let them come and go for drill on weekends. So there may be an employer who says, gosh, this seems like a lot of a challenge, to be able to have one of these individuals working for me. This is considered discrimination, and it may include treatment that occurs because you are in the military. Indicators are patterns of conversations, missed promotions, or assignments made specifically to those in the military. As far as initial hiring discrimination, denying initial employment because of military service, that would be considered discrimination. The bottom line is you do want to hire these folks. They're responsible, they're highly trained, they're drug-free, and they're going to show up to work. Okay, so some of your responsibilities. Go ahead and get the rest of this up here. So Guard and Reserve members who meet the requirements for reemployment rights are entitled to the following Ucera protections. So they're entitled to military leave of absence. So employers are required to grant the employees a military leave of absence to perform their military service. Prompt reinstatement. And then we talked about the periods there. So service for 1 to 30 days, reinstatement will normally be the next workday. Service for 31 days or more, reinstatement will be no more than 2 weeks from the date of application. The position you're reinstated into will usually be the same job that you left, or if you were away for 91 days or more, a position of like seniority, status, and pay. Accumulation of seniority. Okay, now I need to kick this over to this next slide. It's the escalator principle. It's like they never left the job. They step off the escalator at one spot and step back on after their service at the seniority level that they would have earned had they never left for office or left the office. And that is, let me get back in here real quick, sorry. Just to kind of expand on this, this entitles the soldier to the same seniority-based rights and benefits, including pensions, that they would have attained had they remained continuously employed. So for pensions, service members have 3 times the amount of time they were deployed, up to 5 years, to pay any missed employee contributions to their pension plan. Reinstatement of health insurance, health benefits are reinstated immediately upon reemployment. No waiting period and no exclusion for pre-existing conditions. If a service is 30 days or less, Reserve and Guard members can elect to continue coverage at the same cost prior to activation. If service is 31 days or more, Reserve and Guard members can elect to continue coverage at the cost of 102% of the total employer cost. If ESGR gets a pension case, they should immediately refer it to the Department of Labor. We can't solve it in 7 to 14 days. These are too complicated. There's training, if you have instances of training and retraining that's required, if you're no longer qualified due to technological advances or physical limitations, your employer must provide the necessary training to update your skills and retrain you into your new position. Protection against discharge for a limited period of time after returning from 31 days or more of military service. You cannot be discharged except for cause. Good example here is I know we had a couple of high patrolmen who returned back on this last deployment, and I know that with the on the law enforcement side there is a period of time where they have to go back under the field training officers to make sure that they're brought back up to speed for any training that may have lapsed over the time period that they were gone. Okay, so we talked about the reinstatement there. Now, let's talk a little bit about termination. Is there any time a service member may be terminated? And the answer to that is yes. Sometimes service members are terminated during the deployment or upon an attempt to return to employment, but in most cases, this is considered illegal. So the termination exceptions to that are if an employee in a similar position who was not deployed were also terminated. This includes the closing of the company, of the division, or the layoff of a formal group of employees. Even if the temporary position fulfilling their job is better at the job than the service member, you have to hire back the service member. So we understand too that if you have an extended absence of a service member, that there may be someone that has to be hired temporarily to cover that individual. Okay, so now we're going to get into what's called the Ombudsman, who from the ESGR can help with these adherence to the Ucera laws. So we have, each state has at least one or more, depending on the size of the state, of course, ESGR Ombudsman. The Ombudsman is part of the ESGR committee at the local, state, and national level who help reserve and guard members resolve employer-related problems. Ombudsmen provide information to both the reserve and guard members and to the employers regarding their rights and requirements under Ucera. They're available to answer questions and to clarify the law. They're also authorized to work with both parties to mediate conflicts between Guard and Reserve members and their employers due to military service. ESGR ombudsmen do help resolve 90% of employer-related issues that they receive. The objective is to eliminate misunderstandings and to resolve difficulties in the spirit of cooperation at the lowest level possible. Employers and the service members can call the ESGR hotline to ask questions. 99% of concerns are because of the lack of communication between the employer and the service member. So again, I just can't state this enough. If you have one of your employees who's a member of the Guard and Reserve, talk to them, learn about what their service is, what their duties are, so what the level they are within the military, because you have some lower ranking individuals who don't have maybe that level of responsibility that a more senior ranked person, whether officer or non-commissioned officer, have additional duties and requirements that require additional time on their part. So it's good to know what it is about your soldier, I should say, and kind of what their place is within their unit. Okay, so as an employer, the big thing is work with your employee on issues, make sure and communicate regularly with your employee, ask for their drill, their training and future deployment schedules. With regard to deployment schedules, again, with the exception of extreme cases, most of the time a soldier or member of the Guard and Reserve is gonna know very well in advance if they're going to be gone for a extended duration on a deployment. So these are, again, good reasons to have a chat, ask questions like, hey, are you aware of any upcoming deployments where you're going to be gone for an extended period of time? Things like that is always good to pose. Make sure and learn about your service member. Get to know about what kind of a unit they belong to. Are they an aviation unit? Are they in a, an armor and infantry type unit? Are they in a firefighting unit? Are they military police? And it's also these kind of things where you can learn about some of those employer events, such as helicopter C-130 flights. We have invitations to Limestone Hills where we have the gunnery ranges up there. You can learn about the Bradley or tank gunnery ranges, as well as simulator events that we have at the different armories across Montana. Okay, and then as far as resources, this is kind of getting towards the end here where we have some resources. And I think, Tanner, you'll be able to, do you provide the PowerPoint to the participants?
Yes, so we usually do have them out on the website. I apologize. I know we sent a lot of people out to our ABC Clinic website. I think you're the only one that we do not have your PowerPoint up. So I'll get that as quick as possible. I thought that was up there from our last Great Falls, but Parker Sullivan might have asked us not to share it. Or there might have been something there, but anyway, yes, we could get it to everybody. If you wanted to send it to me, Carl,
Sure.
we could get it to everybody's email. Casey Keller West is able to get that sent out, and then we could get it added to the website. So thanks for the follow-up on that.
You bet. The main link for you to get to the Ucera resources is the www.esgr.mil. It's a wealth of resources there. Here's a screenshot of what you'll see there. You're going to have information tabs on supporting your employee, how to nominate your employer, that would be for the employee. You have different state pages, volunteering, requesting assistance. They have the year in review where they do talk about different initiatives from the ESGR. And then there's additional resources in here with regard to the law. And you can see up here on the top, there's the Ucera tab. That's going to have all the information that relates to specifically to the law. So here are the national website. Here's the ESGR hotline. And then the Department of Labor does also have information regarding Ucera. Top 10 reasons to hire a Guard and Reserve member. Global perspective, those that have deployed, they have a different view on the world than someone who hasn't been on a deployment. On time, all the time, first class image. They're calm under pressure. They've been through basic training and some high-speed training that pushes them to their limits on being able to deal with things, being able to manage priorities. They have a can-do attitude. They're going to be physically conditioned because they have some physical requirements there to maintain their service in the military. Mission critical skills. They tend to be more responsible. They're more professional. And number one is the leadership that they can bring to your company. So, and one last great thing about it is that our members all need to be drug-free. And they do get tested on a regular basis. So one other resource for you as employers, you can list jobs at the for free at the ebenefits.va.gov/ebenefits/jobs. So those can be listed there. There is the job seeker network that you can find there as well. You can also send jobs to Parker. She can post some of those on some of the other resources that she has available. So one other thing that's a great benefit for our members is the Military One Source, which is a Department of Defense program providing employee assistance program for those who serve in the military and their dependents, both active duty, National Guard, and reserves. It's a free resource tool for employees to direct their military employees to. The Military One Source provides free non-medical counseling, up to 12 sessions per issue, financial counseling, year-round tax counseling, health and wellness coaching, and other specialists. Military One Source saves the military families money by offering an online tax prep and filing called MilTax. This website also contains a wealth of resources and topics on affecting all areas of military family life, such as education, careers, parenting, retirement. So it's a great resource there. You can push your employees to the contact information here. And finally, your contact in Great Falls, Parker Sullivan. Go ahead and jot down her phone number and her email address. She is full-time there, so if you want to reach out to her if it's a non-critical type question, she may be able to help you with, just send an email off to her. And you can also give her a call by phone.
Great. Carl, thank you so much.
You bet. Thanks,
Right.
everyone. I appreciate it. And I appreciate your time today. And I'll look forward to doing this again in the future.
We do have a couple questions if you got a second.
Sure.
I'll read the first one. It reads, we like to believe we hire those with integrity. We happily respect, support, encourage our military. Sadly, we ran into an issue where an employee has been out for guard duty more than once a month. They embraced knowing we trusted they were being honest. Later, we discovered they had a great camping trip the first weekend and then guard duty the second weekend. Is there a respectful way to ask or verify their commitment for a weekend so we don't take it in the shorts?
Great question. Very, very good question. This is something that I've encountered in the past, and no doubt this is probably a younger individual who did, step up and make an obligation to the military, but unfortunately they've found a way to use this as an excuse to maybe do something that they'd like to get out of work for instead. Scenarios like this are really a great, this is a great time to utilize the ESGR as a sounding board with this kind of a scenario. A respectful way to deal with the employee on it is to ask them for that schedule of drill for the year. If something comes outside of this, it is okay to ask them and say, well, Johnny, you provided me this schedule, and now this is outside of what you had been, previously provided to us. What is there some particular situation there? So it's kind of putting them on the spot. It is putting their good sense of responsibility, at the forefront, whereas them calling, on Friday afternoon because they were scheduled for work on Saturday and saying, oh, hey boss, sorry, I got scheduled for drill, tomorrow, so I won't be able to make it. I think this is a good way to approach that. If it becomes a problem where it's ongoing, that's where the ESGR comes in, and this can be brought up where the ESGR becomes the one that reaches out to the unit and can determine, was there in fact some additional training that was going on that required their employee or that soldier to be gone, or was it in fact something else, going on where they were using their military service as an excuse to get out of work. Again, this is one of those scenarios where the commander, the first sergeant of that unit, will then have a discussion with that soldier and talk about what their responsibilities are, both as a soldier, that integrity and honesty to their employer.
Great, thanks, Carl. And that's tough for all the service members out there. Just one incident could sour a whole bunch of views on it. So thanks for clarifying that, and that employer, for sure reach out to the ESGR if you see it again or have
Yes.
more issues. But thank you
Yeah,
so much,
and you're
Carl.
exactly right, Tanner. I mean, we don't want a soured experience from an employer to prevent them from wanting to hire, a guard or reserve member in the future because of that bad experience, because those definitely are going to become the exception, not the rule. And so we want to resolve, and we want to kind of nip that issue so that it doesn't continue, and it's just going to help that individual develop, as a responsible human being as they progress, both in the military and within their civilian work life.
There was one other question. I believe you did answer it because it came in before one of your last slides. But if you wanted to maybe follow up on it, and then potentially Holly Wolf, if you could maybe address what the job service could help out with. The question reads, where can we post jobs to attract service members, reservists, or guards? We are in the Gallatin County.
Right. So so talk to Parker. She can take individual job postings. We do have a Facebook page that she posts on if there's job opportunities available to service members. Beyond that, we do have on the Department of Labor side, we have a veterans resource. I think Dave Kelly's team.
Yep,
Great.
you're right, Carl. That's our guy, and that's Eric Beal, and he services Gallatin, Marr, and Park County.
Perfect.
So if you have anything open for veterans, he has direct contact with each and every one of them he's reached out to that is unemployed or needs help, and he really does a great job in getting them connected with each and every business that's looking to hire them. So if you want to talk to Eric directly, you can reach him at 406-582-9219. And since we are virtually working right now, he'll pick up those messages and give you a call back. So definitely I can put his contact information in the chat too.
Thanks, Holly. And I personally know Eric, a great individual, does a great job, and he does bring the host of resources that the job service has to bear for any veterans who are job seeking or any employers who are looking for job seekers.
Absolutely.
Perfect. All right. Thank you so much, Holly. Carl, thank you. I think you're off the hook on the questions. You did a phenomenal job. Thank you for allowing the time out of your day to come present to Montana and whoever else may have joined throughout Montana for the ABC clinic. You guys
my pleasure.
Done an awesome job. Thank you.
Thank you, everyone, and wish you a great rest of your day. And I guess I'll go ahead and drop off, Tanner.
Sounds great. Yeah, if you could email me that, and I'll get it sent out to email me a PowerPoint, and I'll get it sent out and posted on our website. Thanks, Carl.
Fantastic. You bet.
We'll see you on the next go around.
Sounds good. I'll I guess I need to stop sharing here.
Yeah, it's on one of the screens.
There we go.
Kind of different. For all the attendees, that's going to be, oh, great, Holly, you were able to put that in there for Eric Beal, his phone number and his email address. Again, that's Eric Beal. He's the local DVOP for the Gallatin County. He has connections throughout the whole state with all the other DVOPs, and so he'll be able to find you some great veterans. We are going to be starting back up tomorrow, same time. Everybody should still have it on their calendar. We do have a handful of topics tomorrow. We have Montana Department of Revenue withholding and e-services, the job service, a little bit more about job service. We just heard from Holly, but we're going to hear from Terry tomorrow. And then the labor market information, LMI, with Matt. He does a great job on letting you know what's going on throughout the state, country, and then even your community, how to look that up. And then the last but not least, we have child support enforcement and new hire reporting. So please join us tomorrow at 2 o'clock. Again, it will be recorded. Anybody that is needing credits will need to put in your name again with what credits you're getting. You could get the CPE credits, the SHRM HRCI credits, or the legal credits. We are going to be tracking it. We do get to see your participation through the Zoom. It kind of says how long you've been on and whatnot. If we have something where you don't have a couple days or a day, we will be following up with you to see what was happening, just to verify the credit. So just heads up on that. We're not policing it, but we just want to make sure everybody is participating to be able to receive those credits. And then also this is our last ABC clinic for this year. We are recording them and we are going to be sharing them out on our website. We shared that earlier. We're going to have each specific topic broken out so people could hear what's going on, and then their PowerPoint along with it as well. So look for that in the future. It probably won't happen right away since we have to edit it, probably take out all my ums and mishaps, but that's something that we'll be working on. So you could expect to see that. Other than that, if there's no questions, I'll be on for another 5-10 minutes, just waiting for people to log off. I'll let you all go and we'll see you tomorrow. Thanks again, everybody.
Thanks, Tanner. Appreciate all your work with this.
Oh yeah, thank you, Holly.
See you tomorrow.
Thank you. See you tomorrow.
Thanks, Carrie. Have a good one.
Yeah, you too.